Welcome to Classes of Mail. Before you listen, you should know that Alan Gegax is not in any sense an official spokesman for the Post Office, the NALC, or anybody else. His opinions are inherently his own and should probably be disregarded. Same for his guests. Any information you hear on this podcast could be wrong and should not be relied upon for any reason. Enjoy the show.
Yeah, buddy. Here we are. We're recording. I hope the audio is coming out okay. I guess we'll find out soon enough. We are in the very professional bedroom studios, guest bedroom studio. And maybe in the mirror, you can even see Annie laying on the bed with us. I don't know. Hey, Michael, welcome to the show.
Hi, everyone.
Everybody, welcome to another episode of Classes of Mail. My name is Alan Gegax, and I got distracted. I didn't even do my proper open. But
And I'm Michael Brazenmoy.
Yep, thank you. Yes, exactly. So this definitely adds a new element. We'll see. For those of you listening on audio, which is almost everybody, I have bought a camera, and it has an audio input that hopefully we can record these episodes also on video, and it'll basically be the same thing except you get to look at me while I'm doing this. YouTube is very popular, so we're going to see how that goes. So that's that. I'll let you guys know where to find it at some point. For now, we're just seeing if we can successfully record this. All right, so enough of this nonsense. Let's get into today's topic.
So I had to wear my Denver Broncos shirt today.
Oh, I didn't even think about what I was wearing. I should have worn something sexy. Oh, well, next time.
Yeah, he'll wear the Buffaloes one.
Yeah, that's true. I do have a Buffalo Bills shirt, but that's all right. For now, let's get to the content.
Exactly.
All right, so today's episode, as you can tell by the title, is about presidential rulings. And as Michael and I went through our issues in our branch, we knew that there were constitutional questions that had to be addressed about what was due process and how does Article 11 really work for appeals and things like that. And there are presidential rulings on these issues. You know, I found them out by going to Google and putting in like NALC Article 11, and I found presidential rulings. And I'm like, oh, these are very informative because this is where the president, the national president, like right now it's Brian Renfro, will dive into these issues and give clarification or expand on what this stuff actually means. Because when you read Article 10 or Article 11, it's pretty vague. You know, it doesn't give a lot of detail. And so what does that due process or what do these processes really mean? So for today's episode, I want to go through some of these presidential rulings and talk about them and what they mean for us as people who are reform-minded within our branches, and how the Constitution of our union can serve us as letter carriers. So the first thing, go ahead.
I remember, we had a couple episodes ago that I talked about how, our Constitution is very muddy language that it's hard to explain. Mm-hmm. And so we need clarification Constitution.
Yeah, definitely.
It's like a lawyer wrote it or something where they just made it vague so that, basically what happens is that the president, whichever president comes in, he can basically make his own decision.
Yeah. So, and by the way, today,
even the national.
Right.
Yeah.
So we're talking about the Constitution for subordinate and federal branches today. When we say Constitution, when we say Article 10, Article 11, the stuff we're talking about as it pertains to your branch. There are like 4 different constitutions in our Constitution: national, state, branch level, and like retirement fund or whatever. But we're talking about the one for your branch. So it's important to note, well, we're going to talk about the themes, I guess, as we go along. So the first thing that I want to do is thank the people who stepped up and volunteered to research some of these rulings for me to take some of that effort off of my plate. And there was one person in particular who sent like a whole analysis of the rulings and I'm actually going to read from some of what he sent me because it was so good.
Yeah, it's tough because Alan is on OT now.
Yeah,
list now,
had to get back on the overtime
yeah,
list.
he doesn't have that much
Dude,
time anymore.
It is amazing how much difference 2 hours a day makes. You know, that was a big chunk of my free time as it turned out. And so, yeah, working overtime, I come home, I walk the dog, I'm like, holy shit, it's already 8 o'clock. I got to get to bed soon. And podcasting takes a back seat,
Right.
especially for episodes like this where we have to do research. Okay, so let's get into it. The first presidential ruling that I want to talk about, you know, I was considering redacting the names from the rulings, but these are all public. I don't think it really matters.
It's under Google, so
Yeah,
I
it's
guess it
all
won't matter.
publicly available. It was
Yeah.
all published in the Postal Record, so I'm not going to bother with redacting them. The first one is out of Branch 70, and this is ruling number 9276 from January 9th, 2024. And, oh, there goes Annie. All right. There we go. Okay. And it reads, oh, one more caveat about these presidential rulings is we don't have access to the letter that initiated this ruling. So we don't know exactly what the question asker sent to the national president in order to elicit this response. And when we had our Constitution class or the bylaw class or whatever with Nicole Ryan, that was one of the things she brought up about, hey, be careful with these presidential rulings because the next president could rule something different, and B, you don't know what the fact circumstances are. But even with that, I think we can take a lot of information from these rulings. Okay, so this again is ruling number 9276. It was January 9th, 2024, which is fairly recent. And it reads, this is in reply to your letter dated December 30th, 2023, in which you asked me to rule on whether Branch 70 President Guzman has improperly restricted your duties as steward to one unit in the El Cajon, Maine post office. By the way, El Cajon's my hometown. I appreciate your concerns and those of the branch members who signed the petition that was sent with your letter. Okay, so just for clarification here, Mari Thompson had her duties taken away from her, where each station had like multiple zip codes, and she was responsible for both zip codes. And then the president or her branch president said, I only want you to work in the one zip code, you know, essentially like, well, taking away some of her duties. And so she wrote to President Renfro, I think it must have been Renfro at the time, to say, hey, I don't think this is right. You know, can he do this? So the president goes on. Nonetheless, I must advise you that there is no basis for any intervention by the National Union at this time. So the national president, not going to do anything about it. And he goes on. Article 6, Section 1 of the Constitution provides that the branch president shall have, quote, general supervisory powers over the branch, end quote, and the authority to, quote, see that officers perform their duties and enforce the Constitution, bylaws, rules, and regulations of the branch, end quote. In addition, Article 6, Section 1 provides that the branch president is chief shop steward of the branch. The branch president therefore retains the ultimate authority to supervise all stewards in the performance of their duties, regardless of whether they are elected or appointed. Any such decision by a branch president is subject to appeal to the branch under Article 11 of the Constitution. The branch's decision may be appealed to the National Committee on Appeals under Article 11, Section 2. So that is his ruling. Now, we're going to see multiple rulings about this same topic, about stewards having their duties taken away. And the duties part is the purview of the branch president. However, there are caveats that we're going to see in future rulings that weren't listed here, because one theme that we're going to notice is that branch presidents are given a lot of latitude, and they can basically run their branch however they see fit, but it's not unlimited. There are still constitutional limits and presumably bylaw limits on what a president can do. And so this ruling doesn't really get into those. It only goes over, hey, by the way, if you don't like what your president's doing, you can use Article 11 to appeal that. And we've talked about that before, but it's important to bring it up here that if your president or if your branch does something that you don't think is right, you absolutely have a right to appeal that under Article 11. All right, you ready for the next one?
Yeah, yeah.
Okay.
I mean, if I'm looking to see if I agree with it, well, I do agree with it, but it doesn't seem like they took the whole job away.
No, it only restricted some of the duties. Yeah, it took some of the duties away.
Yeah.
So there are more issues like that coming up. I got a handful of rulings here. Okay, this one is from Richard McLehose out of West Babylon, New York, branch 6000. This is ruling 8878, December 5th, 2022. This is in reply to your email sent November 30th, 2022, inquiring whether the president or executive board may dismiss a former officer who was appointed to the position of part-time representative in Branch 6000. The answer to your question depends on whether the part-time representative is an elective officer position under the branch bylaws or simply a non-elected staff position. Okay, so this is going to be pivotal to what we want to learn from this ruling, because if the president appoints you to say, like, hey, I need you to update our website, every 2 weeks, and then the president says, I'm done with you, I don't want to use you for the website anymore. That's within the president's purview, unless there's something different in your bylaws, that's fully within the president's authority to do that. However, if the president says, hey, I want you to be our branch's recording secretary, and you become the recording secretary, and then the president says, I don't want you to be the recording secretary anymore, that's a very different thing, and that's what we're going to get into here. So the national president goes on. Article 4, Section 1 of the Constitution allows branches to enact bylaws creating additional elective offices beyond those provided for in the Constitution. A member occupying such an elective office may not be summarily removed. The appropriate procedure for removing an officer is to initiate charges under Article 10 of the Constitution for the government of subordinate and federal branches. For purposes of the Constitution, it is of no significance whether the officer was elected or appointed by the branch president to fill a vacancy. So there you go. The president can't just get rid of officers. You have to go through Article 10 procedures. And you have to bring charges and go through the whole thing. You can't just say, I don't want you to be an officer anymore. The president does not have that authority.
When it comes to officers.
When it comes to branch officers, yeah. All right. If the part-time representative position is simply a staff position, then the Constitution would not prohibit summary dismissal. And any such actions must be consistent with the branch bylaws. In addition, the dismissal would be subject to appeal under the provisions of Article 11. So there you go. There's that theme again, that even if this is something that is appropriate under your president's powers, it's not unlimited. It's still subject to the checks and balances of Article 11. All right. Next, this is from Scott Jackaway in Oak Brook, Illinois. It's almost like reading listener mail. Branch 825. This is Presidential Ruling 9275, January 10th, 2024. Your letter to Executive Vice President Paul Barner, dated December 11th, 2023, has been referred to me for reply insofar as your letter raises issues involving the interpretation of the NALC Constitution. Specifically, you request clarification of your authority as President of Branch 825 to supervise subordinate officers and to set policies for the use of the branch credit card. At the outset, I'm sorry to hear of the apparent divisions in the branch. Nonetheless, it would be inappropriate for me to address the specific issues described in your letter, particularly since I only have your side of the story before me. All right, so in looking at a bunch of presidential rulings, this is very common, that the national president will at all costs avoid actually getting involved in the dispute. And that was very frustrating for us sometimes, that he wouldn't just, hey, you got to do the right thing. He would make his ruling and then that's it. He kind of washes his hands of it. And even the ruling, he tries to stay as vague or as neutral as possible. All right, so going on. I can provide the following general guidance. Please feel free to share copies of this letter with any of the other branch officers as well as the members, or read about it on your podcast. I added that last part. All right. Article 6, Section 1 of the NALC Constitution provides that the branch president shall, quote, have general supervisory powers over the branch, end quote, which includes, we've already read this stuff before. As previous rulings have consistently recognized, this provision confers upon the branch president supervisory authority over subordinate officers. Accordingly, as president, you would have the authority to order compliance with policies regarding the expenditure of branch funds or the use of a branch credit card. A subordinate officer who fails to comply with directions from the branch president would be subject to charges under Article 10. So, once again, the branch president can't just unilaterally institute some kind of punishment. That's what Article 10 is for. If there is to be a punishment meted out by the branch, that's what Article 10 is for. All right. So it goes on. Section 1 of Article 10 provides that, quote, any officer who shall fail or neglect to discharge the duties of his or her office may be removed from office, end quote. Yeah, that for issues of removal. I'm sorry, that's an important caveat. However, under Article 10, such removal cannot take place until... Wait a minute, is this? Yeah, this is the right part. I'm sorry. Under Article 10, such removal cannot take place until written charges have been filed and investigated by an appointed committee and then voted on by the branch at a meeting. The president would also have the authority to temporarily reassign the duties of the non-complying officer to another officer or member pending the disposition of any charges. Expenditures of the branch are governed by Article 10, Section 3 of the Constitution. This section expressly states that all branch funds, quote, shall be devoted to such uses as the branch may determine, provided that no appropriation shall be made except when ordered by a majority vote of the members present and voting at a regular meeting, end quote. Accordingly, officers may only expend branch funds if the expenditure has been approved by members. Previous rulings have recognized that Article 12, Section 3 gives the branch considerable latitude to make decisions about how to appropriate branch funds. A branch may authorize payments in advance through its bylaws or by enacting a budget or a specific resolution authorizing the executive board or a specified officer to make the expenditure in question. So to step back here, that's not uncommon. Like our branch at the beginning of the year sets a budget for the year and, you know, that they're going to spend $1,500 on postage. And so every time they go and buy more postage, they don't have to bring it to the branch as long as they're within that set budget.
Well, there's a part in there about investigation committee.
Yeah.
Okay. That's where I kind of disagree, my opinion.
Okay.
And because the president gets to pick the investigation committee.
Oh, dude, there's rulings on that too that come up a little later. But yeah, it could be a biased process.
Yeah, because every time some investigation happens to go against the president or,
right,
one election committee or whatever it is, he gets to pick his own investigation
prosecutors
committee.
Essentially, yeah.
And so he picks his own friends, and they always win.
If that's a concern, wouldn't it be nice if there were presidential rulings that said you could do it another way so that you don't have these conflicts?
Oh, so
we will get to those rulings.
So stuff that we don't know about.
Yeah, exactly.
Hey, there you go.
Well, I mean, stuff that came up in our branch with the outside people coming in to investigate. Right. It turns out that anybody. Well, we'll get to it. Yeah, all right, but going on with this one, right, what it appears is that somebody at the convention used the branch credit card to pay for their parking or something, and that was not authorized. That's not the way it's supposed to be done, and so that's what created this conflict. So, I mean, just like the letters, I don't have all the details on here, but that's basically, it seems to be what we're talking about. All right, so moving on. The rulings have noted that membership authorization of officers to expend branch funds in the future should be limited to expenses which can be anticipated in advance. Truly discretionary expenditures of a non-routine nature should be approved by vote of the membership in accordance with Article 12, Section 3. So like within our own branch, this is where we're going to get a new copier or we're going to get new chairs or, whatever it is. This is not a standard expenditure that is anticipated and regular. So that stuff has to be approved by the branch.
You mean we approved, and what I didn't approve on was $30,000 for leases, and the only thing they've said was copier and water?
I don't know. I think I missed that meeting.
Yeah, you might have missed that meeting, but I was there.
Yeah. Okay, so going on. If an officer does make an expenditure which had not been previously authorized when made, the members may nonetheless vote to approve the expenditure retroactively. However, this should not be a normal practice. And that's reasonable, right? That the branch can say like, oh, this is no big deal. That was a normal business expense. We're not worried about it. But it still has to be brought in front of the branch. And as the presidential ruling says, that should not be a regular practice. The use of a branch credit card by officers raises serious concerns both under the NALC Constitution and the law. Any expenditures by an officer using a credit card must be authorized in advance by the members in accordance with Article 12. In addition, the Department of Labor recommends that unions adopt clear policies and procedures for credit card use and payment, maintain detailed records to support charges and payments, and regularly monitor compliance with the union's policies and procedures. Ideally, credit card procedures and policies should be discussed and adopted by the members at a branch meeting. However, in the absence of any action by the members, the branch president would have the authority to supervise the use of credit card by subordinate officers and, if necessary, cancel the cards. Finally, your letter also inquires as to whether subordinate branch officers may attend the national RAP session. Over the years, NALC presidents have authorized the expansion of RAP sessions to allow branches to include additional attendees. So long as the NALC continues this practice, it will be up to each branch to decide who may attend. Similarly, branches will have discretion to decide which attendees will be eligible for compensation, so long as the expenditure of branch funds is properly authorized by the members. Okay, so it gets into another topic there at the end, which has come up at our branch, where the superhero is like, hey, this rap session's only supposed to be for presidents. It was like to go somewhere to, I forget where. And why are we sending extra people there? And here the national president weighs in on it.
But it wasn't a rap session. It was a state convention, California State Convention.
Oh, that was something different. You know what? This was a long time ago. It's probably not worth rehashing it.
I'm just saying.
But here it is acknowledged that more than just the president sometimes goes to these things, and while I may not like it, I don't like it. If the branch approves it, well, it's up to the branch. It's the branch's money. And I cannot like it all day long. The branch still voted that that's how they want to spend their money. So be it. Like the Committee of Presidents meeting that we just had in Puerto Rico, that was a lot of money. And as I understand it, like they don't even have classes there. It was just a place to...
Was there anything in there that who picks the people to go?
No, there was not. And from having read enough presidential rulings, it would be up to the president, subject to approval by the branch, unless you have specific provisions for it in your branch bylaws. And our branch did approve that.
Yeah, it was the president
and two
like,
people to be named
Puerto Rico.
later.
Yeah,
to go to Puerto Rico for this
which I
tremendous amount
asked
of
the
money.
question later.
Yeah, right. Who are you going to take with you? Right, and that's a reasonable question.
I didn't forget that.
So,
yeah.
so all of this stuff, right, is all kind of on this under that umbrella of expenditures. And guys, you have to remember that it's the branch's money. It's not the president's money. It's not the treasurer's money. It's your money as a branch member, and you ultimately have the authority over how that money is spent. And if there's any questions, it should be resolved at the branch meeting. But that also means that you have to go to your branch meetings. Okay, let's move on. This one involves somebody close to our hearts, David Grosskopf, out of Cheektowaga, New York, Branch 3. This one is Presidential Ruling 9154, August 22nd, 2023. This is in reply to your email sent August 18th, 2023, requesting clarification of the appeal process provided by Article 11, Section 1 of the Constitution, as it pertains to appeals directed at a decision by the president of a branch. So we can infer here that David Grosskopf made a decision and somebody appealed his decision under Article 11. So it goes on. Article 11, Section 1 provides that, quote, an appeal may be taken to the president from the decision of any other officers of the branch and to the branch from any decisions of the president, which appeal must be taken at the meeting at which the subject appealed from is under consideration and before any other business is taken up for action. So just for clarification here, if this happens during a meeting and you say, hey, I don't like the decision that you just made, I'm going to appeal this under Article 11, everything else stops, and that's what you're doing right now. You are appealing the president's decision. You and the president are going to have a back and forth. That's actually what this ruling is about, is that back and forth. And then the branch is going to vote. And it happens right then. This is an incredibly important check on presidential power. Okay. So going on. There are no particular procedural requirements or standard operating procedures for submitting an appeal to the branch from a decision by the president. The president may certainly respond to the appeal. Both the appellant and the president must be given a fair opportunity to be heard. Ultimately, the members must vote on the appeal at the branch meeting. So, using my context clues, I presume what happened here is like this person appealed something that David Grosskopf did, and there was a back and forth, and the appellant probably said like, hey, this is my appeal. You don't have a right to talk. I'm making the appeal. And so Grosskopf, based on what I can gather from here, reached out to Renfro, or whoever the president was, to say, hey, do I have a right to defend my position in this Article 11 appeal? If he's, somebody's appealing my action or my decision, can I defend it? And the answer to that is yes, right? It is designed for people to get a fair hearing so that the branch who is ultimately going to decide can make an informed decision.
Which is a difference between somebody being charged.
Yeah, right. That's
is
not how Article 10 works.
Yeah.
Article 10 is laid out a little differently. Okay, so where did I leave off? Okay, so thus an appeal challenging a decision by the president made at a branch meeting would normally be made at that meeting and resolved before any other business. There you go, like we were just saying. Appeals can also challenge decisions by the president in which were made between meetings, such as a decision to relieve a steward of their duties. So let me ask you this, Michael. We'll get into how that's handled. If you're not at a meeting and you appeal something that your president has done under Article 11, when should that appeal be heard?
The next meeting.
That is correct, and that is exactly what this presidential ruling says. Such an appeal would normally be made at the first meeting after the decision. Previous rulings have recognized that reading the appeal after the roll call of officers and stewards during a report of communications would be consistent with the requirement that the appeal be acted on, quote, before any other business is taken up for action, end quote. So yes, something happens in between meetings. You don't like what your president did. I'm going to appeal it. That should be the first order of business as soon as you start conducting business at the next branch meeting. And then you and the president, or the appellant and the president, are going to argue it out, and then it's going to go to a vote of the branch. Finally, in response to your third question, the provisions of the NALC Constitution do supersede branch bylaws. However, it would be inappropriate for me to rule on whether the provisions of the Branch 3 bylaws are inconsistent with the Constitution. Generally speaking, disputes over the interpretation or application of branch bylaws must be addressed in the first instance at the branch level. I do note that the bylaw provisions you cited appear to be addressed to the permanent removal of stewards. A steward relieved of duties under Article 6, Section 1 of the Constitution is not considered to have been permanently removed. In that situation, the steward remains entitled to attend steward meetings and to perform whatever duties were not reassigned to the extent consistent with branch bylaws. So that's probably what happened here, is David Grosskopf took away a steward's duties, presumably, hopefully, for the reasons that are laid out in later presidential rulings and are laid out in the Constitution, which we'll get to. And it was objected to, and, that's how this whole process happens. So the person who was researching this for me wrote a little bit on their interpretation of Article 11 and the value that it holds. So I want to read that here. Article 11 appeals cannot be treated like a favor. The Grosskopf ruling is probably the best Article 11 ruling in the set. It explains that an appeal from a president's decision goes to the branch. The ruling does not impose a lot of rigid technical requirements for how the appeal has to be submitted, but the basic rights are clear. The appellant and the president both get a fair opportunity to be heard, and the members vote on the appeal. This is important because a president who refuses to hear an Article 11 appeal is not just being difficult. They are cutting off the constitutional mechanism that reviews their own decision. That is a serious problem. Article 11 is not a courtesy. It is something that it is not something the president can only allow when it's convenient. It is the check on presidential authority. I would use this ruling anytime a president tables an appeal indefinitely, refuses to place it before the members, blocks discussion, avoids a vote, or tries to treat the appeal as optional.
So this is where you have to know the Robert's Rules of Order very well.
Yeah, if your branch runs by Robert's rules, which most do. Yep.
Because some officers, knowing the rule, they will use that against you and then cut you off.
Yeah, absolutely. They'll call for the question, or they'll make a motion to table, or they could do any number of things. Like we heard happen in Branch 70 was when Michael Rivera tried to appeal the denial of a secret ballot vote on his conviction, that his appeal was just ignored. You know, I mean, we're waiting for more information on that, but that I haven't heard anything to the contrary, and I have certainly been asking around.
I mean, the thing is, he was probably right, because the same thing happened in my branch.
Yeah.
Because I brought up the secret ballot, and then the person that came to help us out from a different state said, "Oh, you can't do that."
Right.
And my president goes, "Oh, see, somebody from different states says this," and it violated the rules of the Robert's Rules of Order.
Exactly.
To have a secret ballot, because to have a secret ballot, you have the branch has to vote for it.
Right. You would just vote on this is how we're going to decide this issue is by secret ballot. Yeah, you take a vote, and that's how it's handled. A bunch of shady motherfuckers out there. All right, moving on. You got
that's
something
why.
else? Go ahead.
That's why these things. This is where information is very important. Okay, the more information you know, the more ways you can protect yourself.
That's right. And that's why we're reading these rulings, because it's empowering to know, like, oh, this is how that's supposed to work, so that you don't get screwed over.
Yeah, because when it comes to officers, they will find a way to screw you over if you don't know the rules.
Right. And I would go on to say that, we have a fair amount of branch presidents who listen to this as well. And it's good for you to know, too, so that you don't screw people over, because that is not okay. I disapprove.
Yeah.
All right, next one is from Wendy Eaton in Pasadena, Texas, branch 3876, August 22nd, 2023. This is Presidential Ruling 9155. This is in reply to your email sent August 18th, 2023. I'd like to point out that these typically get answered within a couple of days, which is, good on them. Requesting that I declare charges that have been filed against you baseless. Dude, look at that. This is a branch president who's saying, hey, somebody brought these charges against me. Can you just dismiss them, essentially? You want to take a crack at this one, just at face value, Michael? Well, how do you think the national president's going to decide?
Well, you can't just throw it out because somebody appealed it, right?
It's not an appeal. These are Article 10 charges that were brought against this branch president, and the branch president wants the national president to just rule the charges baseless and throw them out.
You can't do that because the branch makes that decision.
Ding, ding, ding. Let's see if the national president agrees with Michael. Boy, we agree with Renfro on a lot of things. Well, it's just interpreting the Constitution. I know. Okay. While I appreciate your concerns, I must advise that it would be inappropriate for me to intervene in this matter at this time. As previous rulings have recognized, a branch president cannot declare charges invalid on their face so as to prevent them from being processed by the branch. This is the same motherfucker who had charges against him that were brought by Michael Rivera, declared invalid on their face.
Yeah.
Isn't that something? I don't want to say he's a fucking hypocrite. I do want to say that, actually. I do want to say that.
That's
yeah.
hypocrite.
Yes, I do. Yeah, I will say it. He's a fucking hypocrite.
Because it was on him, so he could make that decision,
Right.
Saying, oh, it's no good.
Right, exactly. So once filed, charges must be processed in accordance with, must be processed by the branch in accordance with the procedures set forth in Article 10 of the Constitution. I can provide the following interpretive guidance, which may be shared with the investigating committee and the membership. Article 6, Section 1 of the Constitution specifically provides that the president of the branch, quote, shall, by virtue of their office, be the chief steward for the branch, and they may delegate such authority to other members, end quote. This language empowers the branch president to appoint stewards. The authority to delegate this responsibility, should the branch president so choose, cannot be taken from the president. So if our branch president decided, like, I'm not really in touch with the stations and I'm kind of a dirtbag, maybe I should have the vice president appoint stewards. That's within the branch president's purview, that, hey, you're going to start appointing stewards. But ultimately, that authority still rests within the president, and, they can delegate it how they see fit. Okay.
So all these presidential rulings, Brian Renfro is from January of 2023 to December of 2026 because 2027 will be a new president.
That is the plan. Yes, that is definitely the plan.
Okay. So anything that says 2022, that was Fred.
Yeah. So, right. I know we'll have some rulings a little later that go back further. All right. So, in particular, previous rulings have recognized that a bylaw provision assigning to the branch vice president the duties of chief shop steward conflicts with Article 6, Section 1 of the Constitution and cannot be enforced. So, yeah, if you have a bylaw that, as it says here, if it conflicts with the Constitution, it's unenforceable. You can't do that. Disputes over the meaning or application of the branch bylaws must be resolved in the first instance at the branch level. Accordingly, it would be inappropriate for me to address your Boston Convention and Exhibition Center argument that the provisions of the branch 3867 bylaws cited in the charges is inconsistent with the Constitution. This argument may be presented to the investigating committee and to the branch when the charges are considered. Ultimately, if the charges are sustained, this argument may be raised in an appeal to the National Committee on Appeals. And that's something that I don't know how many of the subsequent rulings that I selected are going to have it, but it will say, like with due process, for example, where it's troublingly common that people who get Article 10 charges against them are not given due process. It happened to Michael and me. We never got asked any questions. We never got to cross-examine our accusers, nothing. And
Because they were told lies.
yeah, basically.
You guys have to do your investigation to protect us.
Right. That the job of the investigator is to find us guilty, is what they were told. Yeah. So anyway, those due process violations are a valid basis for an appeal. And it's not unheard of for the Committee on Appeals to overturn a conviction strictly on due process grounds, because we can't have a conviction where, like the defendant never got a chance to actually defend themselves. That's not a valid conviction. I have seen rulings where they remand back to the branch and give the branch a second bite at the apple. I don't know how I feel about that necessarily, but these due process grounds are a valid reason for an appeal. Okay, moving on. The next ruling is from Catherine Tondreau, Taylor, Michigan, branch 2184.
How many more we got left?
I don't know. Oh God, we're already at 37 minutes. Dude, we have quite a few. We might have to do another episode.
Then maybe
on
do a
these.
part 2.
Yeah, we might have to do a part 2. Because, dude, these are so interesting. I hate to not do it. But thank you for pointing out the time.
Yeah, we like to keep it around 30 minutes.
Yeah.
So that you wouldn't get too bored.
Okay.
Boring.
Yeah, this will be the last one. And then, we're going to have to do a second episode.
Yeah.
Okay. This is Presidential Ruling 9077, June 16th, 2023. Hey, that was my 48th birthday. This is in reply to your letter sent by email, June 14th, 2023, regarding the charges that have been recently filed against the president, executive vice president, and a steward of Branch 2184 under Article 10 of the Constitution. According to your letter, a 3-member committee has been appointed by Branch President McGregory, which you assert is not disinterested. Your letter requests that the National Union intervene in this matter and appoint a new committee to investigate the charges.
Oh, this is what I was talking about earlier.
Yeah, exactly. Right. A lot of this stuff is addressed, and that's why I find these rulings so interesting. At the outset, I must emphasize that I have no firsthand knowledge of the facts. However, your letter does indicate that the committee... Dadgummit. I lost it. That the committee... there we go. May not have been appointed in accordance with the Constitution. Article 10, Section 3 of the Constitution provides that the committee to investigate the charge is to be appointed by, quote, the president, or if the president be the person against whom the charges are made, the vice president, end quote. If both the president and the vice president are charged, then the next highest ranking officer should normally appoint the committee. If, as you assert, Brother McGregory is named in the charges, then he should not have appointed the committee.
Oh, look
Yeah,
at that.
no shit. Yeah.
Our president that he chose,
Well-
and it was against him.
Well, I mean, he didn't appoint the committee to investigate himself.
Yes,
but
he did.
I don't think that's true,
Yes,
dude.
no, he did.
Not for his own charges. I
Especially
think he had the vice president select
Lori
that
too.
committee.
Remember Lori?
Yeah.
He appointed
I think the vice president did that. All right, look, dude.
Okay. But anyway,
Yeah.
that's already done and over with.
So,
So we know for next time.
Yeah. He should not have appointed the committee, and the committee should not proceed with the investigation. Please note that I am providing a copy of this letter to Brother McGregory as well as the other charged parties. It appears that some level of scrutiny by the National Union is warranted. Oh, we've gotten those letters before, because it has certainly been warranted at our branch, to ensure that the charges are investigated impartially and in full compliance with Article 10. Therefore, by copy of this letter, I am directing National Business Agent David Mudd to investigate the situation and provide whatever assistance the branch may require. In accordance with my authority under Article 9, Section 1 of the National Constitution, I'm authorizing Brother Mudd or his designee to appoint the committee if he believes it is in the best interests of the branch for him to do so. The committee may include disinterested members from other branches.
Yeah, so here's the problem with the disinterested people, okay?
Yeah.
Because like our president would pick his friends that he knows that's loyal to him.
Sure.
He'll pick them, and then anybody that's our friends, no, they're disinterested. They're not disinterested, so we can't use that.
I mean, this is the problem. And so, look, what we're learning here is that if you think the party is not disinterested, if you think they're not going to be fair, that's an appropriate reason to write to the national president and request an outside investigators to come in and take over the process.
And that works, by the way, because that's what we did.
Yeah. And we got a much better investigation out of it.
Yeah, better, but
I mean, dude, in the investigation, in the trial, essentially, they stood up there and admitted their wrongdoing, and the branch still voted them not guilty.
Yeah,
but I mean, it happens. Well, that's the way the branch voted.
The problem with that is that when we vote, they know when that voting happens because the investigators.
Right.
They tell our officers when
and
they're going to
when
vote.
It's going to be
but they don't tell us.
No, they don't.
They tell them.
Yeah.
Okay.
Right.
And so they know when they're going to be voting. So you know what they do? They call all their friends in advance to come to the meeting to vote for them. Okay. So you don't know if that's happening or not. Because,
it's true.
Because investigation.
You don't know if it's going to come up this month or not.
Or the next, because they've been getting extensions. So you don't know if it's this meeting or the next meeting. Yep. They don't tell you.
Yeah.
But somehow the officers know when that's going to happen. So they're always in favor of these things. And to me, that's a problem.
Yeah.
Okay. But at least we know that we can file to the president and say, hey, I felt like I was being mistreated. So. But you have to have some kind of proof why you felt that you were mistreated.
Definitely.
And let them decide.
Yeah, and you have to be able to point to, like, this is where I think the violation is, or this is what I think the problem
person is not disinterested because this person works under this person. This person is not disinterested because this person works under this person, and so forth. Right. So you have to still kind of prove why this person is not a disinterested party.
Right, because as we have learned, at the national level, they are very reluctant to get involved in branch issues.
So you have to prove everything.
Yep. All right. We are good, dude.
Yeah, and then we'll go to part 2.
Yeah. So
all
right.
We'll see you guys for the next episode.
Yes, indeed. Thank you, everybody, for listening. We'll catch you all next time.